Well, good afternoon, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. And yes, we are getting back onto our brand new HIPAA series. But before we do, brief disclaimer everything that we are going to be covering throughout the entirety of this HIPAA series, all the different sources of information we're going to use as we go throughout this particular series. You're going to find also linked up for you right there in the description box. So, should you like to go ahead and do a deep dive on the subject on your own, you're definitely going to be able to do so. Trigger warnings. We're going to start with the political warning. If you are extreme right or extreme left, whatever iteration of said one of the other that you may be, I am not. Which means at some point during one of these series, there's something more than likely that I am going to say that is probably going to offend some folks. If that is not the type of thing that you are able to handle as an adult, and the concept of agree to disagree doesn't exist for you, I would advise possibly staying away from the comments section. Because any post hominin attacks, any Trump derangement syndrome, dear God, please find some creativity. It's boring. It's old. It's been old for 2 years, for the love of God. I will simply delete your comment and block you off the channel because nobody has time for that, especially not disabled folk, alright? And yes, I am autistic. I don't have time for it. Believe me, alright? Cool. Alright, other trigger warnings. This channel is marked not for kids for a reason. I do use profanity and some of the other topics that we do cover on this channel, like the Judge Rotenberg Educational Center, is done on some pretty dark stuff. So if you got a child that is 16 and younger and they are watching the channel, parental supervision is very much advised, alright? Alright, I never look good on this camera. He's like, nothing I can do, folks. Nothing I can do, because in the mirror the hair looks spectacular. And I look on here and it looks like I'm getting close to my younger kid days where it like slowly turns into a gigantic boof. Anyways, general principle for uses and disclosures, where we left off last time. Now, our introduction, remember I'm giving you a full overview and there's a lot of information to go over even during the overview. So probably more than one episode of this series is going to be done from this website. Basic principle. A major purpose of the privacy rule is to define and limit circumstances in which an individual's protected health information may be used or disclosed by covered entities. A covered entity may not use or disclose protected health information except either 1. As the privacy rule permits or requires, or 2. As the individual who's the subject of the information or the individual's personal representative authorizes in writing. In other words, the only one who gets to decide who gets to see my medical information is me. If there's anybody else that needs to be included and have that information shared, such as, for example, with my psychiatrist in primary care, then there is an actual legal form documentation that has to be filled out with witnesses and everything so that that information could then be shared through means such as email and what have you. Required disclosures. A covered entity must disclose protected health information in only 2 situations: to individuals on their personal or their personal representatives, specifically when they request access to or accounting of disclosures of their protected health information, and B, to HHS when it's uptaking a compliance investigation or review or enforcement action. You have to excuse me if that doesn't fill me with relief. And if you guys want to know why, when HIPAA was originally done, hell yeah, I felt protected. We have RFK Jr., the water is making the frogs gay, as head of HHS right now. Yeah, I'm glad that I had all of this done previously, even if all it does is buy me time. But not the point. Let me go ahead and continue, shall we? Okay. Permitted uses and disclosures. A covered entity is permitted but not required to use and disclose protected health information without an individual's authorization for the following purposes or situations. So, only on these occasions are they allowed to share that protected health information with anyone. Number one, to the individual, unless required for access or accounting of disclosures. Number two, treatment, payment, and healthcare operations. Number three, opportunity to agree or object. In other words, somebody has asked for your information. If this is something that you're aware of, is this something that you want to happen? That sort of thing. Four, incident to an otherwise permitted use and disclosure. Five, public interest and benefit activities. Who wants to bet that's what RFK is banking on right now? With his, we're gonna know what causes autism by September. Dude, I can fix that for you before September. It's called genetics and environmental factors. And no, I'm not talking about the type of environmental factors that come with it. Getting your normal shots like everybody should. How anyone can trust that man in regards to vaccines when this is literally the dude. Literally the dude forced his kid to go with him to cut the head off of something they found on the beach. I mean, people, are you even serious? Sorry. I just can't deal with it, folks. Cannot deal with it. Covered entities may rely on professional ethics and best judgments in deciding which permissive uses and disclosures to make. Okay, I've already read over that. Excuse me for that. Now, 5, public interest and benefit activities, and 6, limited data set for purposes of research, public health, or healthcare operations. To the individual, a covered entity may disclose protected health information to the individual who's the subject of the information. So, in other words, my psychiatrist can speak to me in regards to the contents of my medical history that she has access to at any point in time. Treatment, payment, healthcare options. A covered entity may use and disclose protected health information for its own treatment, payment, and healthcare operation activities. In other words, they are allowed to share that information with your insurance company, is what that is there for. A covered entity also may disclose protected health information for the treatment activities of any healthcare provider, the payment activities of another covered entity and of any healthcare provider, or the healthcare operations of another covered entity involving quality or competency assurance activities, or fraud and abuse detection compliance activities if both covered entities have had or had a relationship with the individual and the protected health information pertains to the relationship. So, a lot of this has to do mainly with insurance. Yes, even when they're kind of talking about providers, because specifically what they're kind of referencing to here is in regards to insurance building for different treatment programs, right? And a lot of those different treatment programs that are usually put up and coded in documents by individuals who are called medical billing encoders. So they have that information to be able to use to get things properly coded and sent off to your insurance agency so that your healthcare provider can receive payment for services. So that is what that disclosure in particular is in reference to. It's not the kind of threat I am worried about. I think I've already told you guys what I'm worried about. Let me go ahead and continue here. Treatment is the provision, coordination, or management of healthcare and related services for an individual by one or more healthcare providers, including consultation between providers regarding a patient, referral of a patient by one provider to another. For example, things went a little bit backwards for me, and I got reference to a few primary care physicians by my current psychiatrist. Not psychologist, my psychiatrist. I've got a team, folks. Anyways, so she can use my medical history to refer me to a primary care physician, for example, when they are nervous due to the medications that they prescribe to me in regards to my tachycardia. So, primary care physician and psychiatrist can speak with one another in regards to my medical history to make sure whatever medicines either one of them prescribe will not, badly affect what the other doctor is prescribing. It's better coordination. Make sure that they're not just simply throwing pills at you and everything goes wonky. When I talk to you guys so much about talking to your doctors about your medication, this is the sort of thing I'm referencing. This is the kind of head knowledge we gotta have. Not just to protect our information, but to also make sure that one doctor is not going to prescribe you something that's going to knock out the effects of another prescription you may already be on, or if it will have a detrimental and even dangerous effect. For example, if you take one pill in the morning and the other you're supposed to take at night, but nobody tells you this, like they did to me in high school. So now you're taking 100 milligrams of Zoloft, and you are also taking 150 milligrams of Adderall at the same time. And yeah, I'm pretty sure that's why I have the spasm issues in my legs. So that's the sort of thing that they are talking about there. Of course, payment, exact same thing. Healthcare operations, that also has to deal with medical billing and coding as well, but we are going to go ahead and read through it anyways. Are any of the following activities quality assessment improvement activities, including case management and care coordination? A lot of that care coordination usually works with your service providers. To give you more of an example here, that would be like my coordination between the services I receive through the state being coordinated with my psychiatrist and doctor, with my case manager, and say I was still with ARC. All of those folks would remain in an open line of constant communicata all the time with one another. That's what they're kind of talking about here. Competency assurance activities, including provider or health plan performance evaluation, credentialing, and accreditation. Conducting or arranging for medical reviews, audits, or legal services, including fraud and abuse detection and compliance programs. So, should they ever need to audit you for something they think might possibly be fraudulent, specified insurance functions such as underwriting, risk rating, and reinsuring risk, business planning, development, management, and administration, business management and general administrative activities of the entity, including but not limited to de-identifying protected health information, creating a limited data sheet, and certain fundraising for the benefit of the covered entity. Most uses and disclosures of psychotherapy notes for treatment, payment, and healthcare operations proposes require an authorization as described below. Obtaining consent, written permission from individuals to use and disclose their protected health information for treatment, payment, and healthcare operations, is optional under the privacy rule for all covered entities. The consent of a the content of a consent form and process for obtaining consent are the discretion of the covered entity electing to seek consent. So I've done those before. I've signed one for my mom just in case something went like 6 ways from Sunday very, very wrong. But yeah, that's what those have to do with. Uses and disclosures with opportunity to agree or reject. So these are where the healthcare provider has to ask your permission. And if you tell them no, then that's where it ends. So let's read through that. Informal permission may be obtained by asking individuals outright or by circumstances that clearly give the individual the opportunity to agree, acquiesce, or object. Where the individual is incapacitated in an emergency situation or not available, covered entities generally may make such uses and disclosures. If in exercise of their professional judgment, the use of disclosure is determined to be in the best interests of the individual. That is something we are covering: advanced directives, living wills, things of that nature. That's some of what they're talking about there. There are some permissions, some forms that you have to sign. In particular, if you do have a living will going and you have someone, in the case of God forbid, end of life scenario, if you got someone who's set up for your healthcare proxy, you're going to have forms signed for permission for that to transfer over to them in the event that you become incapacitated. Facility directories. It is a common practice in many healthcare facilities, such as hospitals, to maintain a directory of patient contact information. A covered healthcare provider may rely on an individual's informal permission to list its facility directly to the individual's name, general condition, religious affiliation, and location in the provider's facility. The provider may then disclose the individual's condition and location in the facility to anyone asking for the individual by name, and also may disclose religious affiliation to clergy. To give you guys an example, because I've been around the Mercy hospitals, God, forever, and then before that, the state hospital. But literally, kind of what that is when your loved one goes into the hospital and you want to call and check in on them. Usually, they give you what I like to call the Clip Notes version. It's usually vague, it's not very specific, but you know where they are, which room they are currently in, what your current health status is. Essentially, are they okay? Are they getting better? Things of that nature, right? That's the sort of thing they're talking about there. For notification and other purposes. A covered entity may also rely on an individual's permission to disclose to the individual's family, relatives, or friends, or to persons with whom the individual identifies, protected health information directly relevant to that person's involvement in the individual's care or payment for care. This provision, for example, allows pharmacists to dispense filled prescriptions to a person acting on the behalf of the patient. So, in other words, if I'm incapacitated and my durable power of attorney that makes my mom my medical care, healthcare proxy comes into effect, this is going to give her the ability through the documents I signed throughout that process to be able to go in and pick up medications for me at the pharmacy. Similarly, a covered entity may rely on an individual's informal permission to use or disclose protected health information for the purpose of notifying, including identifying and locating family members, personal representatives, or others responsible for the individual care of the individual's location, general condition, or death. In addition, protected health information may be disclosed for notification purposes to public or private entities authorized by law or charter to assist in disaster relief efforts. So, if something's gone wrong with you, this is where they would be able to provide that information to your loved ones. So, that's the sort of thing that's going on there. It's very limited in the scope in regards to what they are allowed to reveal, but they are able to give family members basic information unless you do have more advanced directives and paperwork already taken care of. Which we'll be continuing to talk on that subject coming up this Sunday. So, all right, incidental use and disclosure. The privacy rule does not require that every risk of incidental use or disclosure of protected health information be eliminated. A use or disclosure of this information that occurs as a result of or as an incident to an otherwise permitted use or disclosure is permitted as long as the covered entity has adopted reasonable safeguards as required by the privacy rule and the information being shared was limited to the minimum necessary as required by the privacy rule. See additional guidance, and we'll go into the additional guidances as we go throughout the series. I don't want you guys to be worrying about that. Public interest and benefit activities. The privacy rule permits use and disclosure of protected health information